Recording in progress.
So with this, a very good evening, ladies and gentlemen. I'm your host for the evening. I'm Tia Sudi, would like to extend a very warm welcome to you all for WIPF 2022. And after a great day of yesterday and indeed the morning sessions, I hope you all had wonderful time. And again, we are all set to start the last session of the evening, and it is going to be a session full of learnings, exploring and exchanging new ideas. So with this, without taking your much time, let me introduce our session for the day, that is Artificial Intelligence and Intellectual Property. And now let me introduce our moderator for this session. We have Professor and Dr. Mei-Hsin Wang. She's a fellow at Royal Society of Chemists, UK from Taiwan. A very warm welcome to you, ma'am. Yeah, can we have a round of applause, everyone? Yes, thank you. Now moving ahead, we have our speakers for this session. So in the beginning, we have Mr. Kirk A. Sigmon. He is working at IP attorney at Banner, Witcoff, USA, and he'll be speaking on tips and tricks for patenting artificial intelligence in 2022. A very warm welcome to you, Mr. Kirk. Moving ahead, we have the next speaker of the session, Mr. Chirag Bansal. He's a senior attorney and IP specialist at LS Dower and Company from India. Once again, can we have a big round of applause, everyone? So he'll be speaking on artificial intelligence and Indian patent regime. And at last, but not the least, we have our next speaker, Mr. Yanis Skoulikaris. He's a founder and managing director at Patent Mind Netherlands. Peter Blue from Netherlands. A very warm welcome to you, Mr. Yanis. I hope I pronounced the right name. So with this, we are all set to start the session. So if you have any Q&A, you can ask with the speakers. And now I would like to hand over the mic to our moderator, Mr. Mei-Hsin. And I request you to please introduce our speakers. Yes, over to you.
Good afternoon, ladies and gentlemen. It's our pleasure to present you this panel, Artificial Intelligence and Intellectual Property. Before we start the presentation, please allow me to briefly introduce our honorable speaker. Our first speaker is Mr. Kirk Sigmon. He's an IP attorney at Banner Witcoff. He comes to clients at all stages of invention, patent prosecution, intellectual property enforcement, and litigation. And Kirk began his legal career in Tokyo and routinely worked with US, Japan, Korea, Chinese, and European intellectual property matters. Kirk's cases have involved a broad range of technology, including computer networking, cellular communication, video gaming, virtual reality, machine learning, AI, a military weapon system blockchain, etc. And our second speaker is Chirag Bansal. He's a senior attorney at LS Dower Corporation, India. He worked with LS Dower Corporation in the capacity of patent attorney. And he's registered as an Indian patent agent and holds a master's degree in computer science engineering. Chirag possesses a rich experience in field of patents, and he's responsible for patent prosecution, drafting, representing clients in oral proceedings before the patent office, and handling contentious matters. And our most senior speaker is Yanis Skoulikaris. He's the founder and managing director of Patent Mind Netherlands. He has been working with the European Patent Office for 30 years, starting from patent examiner and becoming the director for patent granting process and information communication technology. During his career in EPO, he has co-drafted the examiner's guideline for examination of computer-implemented invention, including AI inventions. Nevertheless, he managed bilateral concurrent study with the Japanese Patent Office and Chinese Patent Office for the computer-implemented invention. During the year of 2020, he founded a group of companies branded Patent Mind. It's a synergetic network of distinguished IP professionals operating as independent intellectual property consultancy and training, specializing in patenting software and AI technology. And he's Panama LLC, operating as a rescue service for the most difficult challenging patent cases. And he supports his clients as technical experts in court in fighting effective accurate brief, as a technical qualified judge for upcoming European Unified Patent Court. And he's a guest lecturer at the Law School of Massachusetts University and Washington University, St. Louis. He's a native speaker of Greek, influencing English, German, and working knowledge for French and Dutch. Member of IEEE, LSI, AIPPI, and AITLI. So before our honorable speakers start their presentation, allow me to present you a few AI big data tools which have changed our daily practice. For example, this is Lex McKenna. In all days before we go to the poll, we haven't done a lot of cross study for our counterparties, attorney, and the judges. But we don't have very clear figures. Also, the current AI big data tools, you may imagine in the future, if you get into a call with Google Glass or other glasses, then there will be a judge tell you the overall situation for the judge, for the jury, for the witness, or even your counterparty's attorney's experience, make your life much, much easier. And somehow, during our career, you have to take up some trademark measures, searching counterfeits, competitors. But if you look at these bottles, they don't look very similar, right? But hairier, sexier, crazier, flirtier, sexy, how can you do the search? So you definitely need the AI and big data tool. For example, the naming tool from Clarinet. They will help you to conduct a search identical or identical with different class, or with different letters, prefix, infix, suffix, or even have the vowel changes, the consonant changes, or another grammars. So the AI change our daily practice. They will help us check the trademarks in different regions, legal status, the wordings, and also whether they are exactly similar in which region, or with elements similar or other class, or somehow they may be also inactive. With the image or the figures, you can see easily just dragging these icons, and they will help you to find all the similar arts. As you can see from the screen, it's impossible without the tool to help us to work on IP nowadays. So this is a socket also from Clarinet. And how about these four trademarks? They look the same. So our daily operation is very much different. For example, if industry design, there's also can be helped by those AI tools. .IP, they could help you to gather, organize all the cases all over the world. So for example, how many times your plaintiff have suing each other, the case history, just one click, two click, you get all the details globally. The tool for patent quality, they will help you to access patent quality, patent portfolio, patent validity, or even they will help you to design the run. So nowadays, AI helps us for actionable patent intelligence, unlimited design possibilities. So they will help us to overcome the language barrier and also overcome the technology barrier. And for example, this is the search I did for blockchain. Quickly, just in 30 seconds, I can get all the list with quality or their values, gradings, and the list of all the patents, technology-wise or company-wise. So it's very interesting, or even they will help you to find the correlated cooperation. So searchable file wrapper assist about validity issues. They offer multi-product search. They will support the claim chart creation and also invalidation supplementary arguments for the prior art references exhibit. Also, they will help us to use AI. This is a tool from IPV, the Zeus Analytics. They will analyze, compare with all the patent office and all the searchable papers based on the international classification, the network of their related patents, the textual similarity, the claim structures, the number of element match, and they will give the grading, help you to make the decisions. So rating, valuation, answers, or even transactions, they all can be helped by AI. So licensing, sales, smart pool service, patent-based secularization, patent-based lending, insurance, risk management, all these tools, they help us to create a new IP ecosystem. So now I will turn my floor to Mr. Kirk Sigmon. He will give us more comprehensive detail how AI machine learning will be processed during this IP practice.
I'm going to have to stand up because I'm still a little bit jet lagged, so if I sit down too long, I'm going to fall asleep. I'm going to go ahead and jump forward a little bit. So today I'm going to be talking about something that's a little bit obvious to many of you. Many of you will know many of the things I'm about to say. I'm not going to blow into your minds here, but I'm going to give you the highest level idea of what's going on in terms of how my firm and many firms like it are looking at patenting artificial intelligence and machine learning. Specifically, this is the instructions that I give to associates underneath me. These are the instructions I provide to our clients. This is what we're seeing. And I say this after hundreds of different patent applications we have worked on. I personally manage about, I think, 300 right now directed to AI. That's a small fraction of those that we're handling at this point. So all of this is just accumulated learning over years and years of working on this and everything else. But before that, let's again a little bit, first of all, disclaimer, I'm not your, you can't be my client. Most of you probably won't be your client. Let's talk about the growth of AI. So in general, in recent years, we have seen a distinct growth in interest in artificial intelligence in patenting world. Now, let's be very clear here. This chart, which is kind of hard to see admittedly, there's one thing that this hides. This is talking generally about the fact that we're seeing a growth in patent families that talk about artificial intelligence. Between me and you, they're not really directed to artificial intelligence. They are applications that somehow mention it. Somewhere in that document, the words machine learning model appear or artificial intelligence appear. This is extremely common. So one thing to understand is that you should not be surprised if your clients come to you with sort of discussions about artificial intelligence in the context of something that is far, far, far unrelated to artificial intelligence in the first place. This commonly comes into play in a variety of ways. So I'll give you an example. Many of my clients in the telecommunications space will come to me and say, well, let's make sure we have some artificial intelligence in there just in case. And needless to say, we'll put it in there, and that will make it an artificial intelligence patent, but it's not really. It's just kind of there. So don't be deluded by this. This is kind of misrepresentative. But who's filing here? It's kind of your general who's who of the companies you expect. You've got IBM on there, you've got Microsoft, you've got some Chinese universities, you've got Sony, exactly who you would expect. The companies who are actually going after artificial intelligence patents time and time again tend to be exactly who you would think are going after those patents. The remainder of them tend to be sort of artificially or tangentially related. So what is my firm seeing? This is basically a summary here. Basically, everyone wants a piece of the artificial intelligence pie. It is a valuable area. It makes you look like you're doing something cool, even if you're not. And in general, there's a sense that if you do it correctly, you could possibly get your way into a patent that you might not otherwise be entitled to. In other words, if you do it correctly, you might be able to convince a patent examiner to allow an application that otherwise would not be allowed. Another thing to be aware of, however, is that this is resulting in smarter patent offices. This applies to the US, this applies to Europe, this applies to Japan and Korea, and everywhere else you could possibly imagine. The patent offices are not falling for that trick anymore. They know that stapling artificial intelligence to a boring idea does not make it an interesting idea. And that in turn, that means that you need to come at these applications with much more thought. They need to be kind of more robust. And I'm going to explain what I mean by that in a second, but just keep in mind that in general, the standard's harder now. So you need to be a bit more clever and not just say, do that cool thing with artificial intelligence because your patent will never be granted. And again, in general, there is much more research in this area. In our knockout search that we perform before we file a patent application, we are finding much more discussion online, on forums, on discussion boards, on research papers, everything. In general, everyone's interested. In ergo, that means that you're going to have a harder time getting over sort of prior art rejections. So how the hell do you deal with it? I've said it's popular, everyone's trying to do it, and the patent offices are going to make your life a lot harder. So how do you actually get an artificial intelligence patent in 2022? Here's what I recommend. First of all, let me show you what not to do. This is an application from the United States, and I'm actually going to expand this if you don't mind, because it's kind of hard to see. So this is an example of something that I have told people you should never ever do. And this is an example of a type of claim that it seems cool on paper because it says, you know, a computational component, including a predictive model trained on data labeled by at least an agent computation component. That sounds really technical, but it's a lot of crap. And it's not going to get you a patent. I'm sorry, it's just the truth of it. This is someone who clearly attempted to make it sound really technical, but it was not a very clever idea. And these patents, these patent applications exist in droves. You're not going to get a patent on this. In the US, in Europe, and anywhere else, everyone's too smart for this nowadays. Don't go do it. Here's another example that I would say is risky, something that people still do that you probably should stop doing. It's a very short description, and basically what it's saying is it's about questions. So this is a patent application directed to evaluating an individual for a behavioral disorder. So it's like figuring out the kind of a problematic person, we'll say. And it says you're going to give a bunch of questions, you're going to receive an input, and you're going to generate an output, and that output is going to be based on a statistical accuracy of at least 90%, and the input's going to be there, and there, you know, this is not very clever, is it? It's just not. Like, we have to be realistic with ourselves. There's a sense that this is somehow trying to get clever, and it's trying to get at the idea of artificial intelligence, but it doesn't work. And they tried to fix it by shoving it in that at least 90% thing. It didn't work, actually, but they tried. So this is another example of the type of thing you shouldn't be doing nowadays. Here's a better example. It's not perfect, but it's a better example. And you can barely see it, I apologize. But the basic idea is it says, look, this is actually the same idea. This is a behavioral disorder patent, so you're asking people questions. But what it's saying is you're receiving responses to some sort of input, so in this case, answers questions about a behavioral disorder. And it's saying we're going to generate an output based on said input using a software module comprising a classifier trained with data from a plurality of individuals having a behavioral disorder, yada, yada, yada. You get the idea. So we're talking more specifically about a very specific machine learning model that is trained to do a very specific thing that produces very specific outputs. So we're beginning to get a bit closer to the kind of thing we need to see. So what's magic about this? In part, it's the idea that you are being specific about the model. Most patent offices are not impressed by you saying machine learning model anymore. They analogize that to algorithm. However, when you begin to say things like, no, it's very specifically trained, now you're telling a story. You're telling a reason why you developed this. But I still think this is not enough, so let me show you what I actually think you should be doing. Actually, before that, let me go ahead and show you. This is my little diagram I'd like to show everybody about what not to do. There are many, many patent applications that do exactly this. They say, I'm going to give an artificial intelligence, I'm going to give an AI model some input, it's going to produce some output. You will not get a patent this way. Everyone tried this back, 10 years ago, and we're all burned out on it. Please don't do it. It's just not working. It doesn't work in the US, it doesn't work in Europe, it doesn't work anywhere else. In other words, if your patent looks like that, or your first claim looks like, I'm going to train a machine learning model, provide an input, and get output, it's not enough. Not anymore. It never has been, but definitely not now. Here's where I like to focus many of my clients now, and this is probably one of the more pertinent ideas. What I want you to think of is artificial intelligence in a bigger scheme. This is typically implemented in a way that tells a story bigger than artificial intelligence. And another way to think about this is, what I am saying is, you're not actually going after artificial intelligence. It is one piece of the puzzle of your invention. In other words, if your inventors come to you and say, I've invented this new way of doing artificial intelligence, you need to ask them, well, why are you doing that? What's really going on here? So what I'm saying is, you have this overall concept of different things that are going on, different aspects that lead to an input, different aspects that lead to an output. And at some point in the middle there, you might have an artificial intelligence doing some work. You might have a machine learning model doing something. But that's not the entire story. Your story, ideally, is this is one piece of the toolkit that gets me to this cool result. So this is not perfect, but this is oftentimes where I like to try to push my inventors, saying, look, the real reason you're doing this is not because you are a genius in artificial intelligence, probably, but because instead you've likely found something interesting about artificial intelligence. You've likely discovered something that you can do with artificial intelligence that no one else has done before. This is where I like to push them a little bit, but I've got an even better approach. I'm going to jump forward here. What I'd like to do is focus them on a recursion model. What I'd like to do is say, look, I want you to explain to me how you're training a model. I want you to explain to me how you're receiving the data that you put into that model. I want you to tell me how you're using the model and doing something useful with the output of that model. And then I want you to tell me why we're training it again. Because 9 times out of 10, when your inventors come to you, this is kind of what's going on, even if they're not explicit about it. So let me rephrase this for a second. What I am actually saying is, your inventors are likely using artificial intelligence because it's able to learn, obviously. Ergo, what you should do is talk to them about how it's learning and how it's continuing to learn. Because not only is that something that's above and beyond a conventional computing algorithm, but it begins to tell your story better to the patent offices. They respond extremely well to this, in my experience. I have many, many banking clients who, candidly speaking, would never survive most of their patent applications, would it not be for the fact that they can tell this story. So let me put this again. Let's say, for example, I've got an example claim over here just to provide you an example of what I would do hypothetically. So you see here I say, first and foremost, I'm going to explain to you exactly how I trained that model. And typically this is different data than anything else in the rest of the claim. So it's saying, look, I'm going to train using training data comprising a plurality of pictures of dogs in different environments, a machine learning model to identify a dog in a photograph. So I told the story, okay, we got this cool machine learning model, we trained it really well. We're going to get from a CCD sensor a first image, we're going to provide that image to the trained machine learning model, and we're going to get some sort of output data, and it's going to predict the location of the dog. Note that what I've done here is I've told you, we got a machine learning model, it's really cool, here's what we're getting it, here's what we're getting from it. And all these are highly technical to get around sort of obvious subject matter eligibility concerns that you might experience in the US and Europe and India and everywhere else. Then we're going to basically do something useful. And this is a term I use with my inventors all the time, and I recommend you use something similar. You have to tell them, look, the output alone is probably not enough, because again, we're trying to distance ourselves from the impression that this is all just an algorithm, a conventional computing algorithm. So what you say is, look, what are we doing with the output data? Well, some clients will tell you, well, it'd be really cool because we'll know more. Why? Right? In this case, I've given an example, transmitting to an alarm system a notification that dogs enter the property. This is a stupid example, but in general, you have to come up with something you're doing with it. So note again, the machine learning model is actually a very small percentage of what we're doing here. It's a fraction of this entire claim. But here's where the really cool stuff happens. This is how you get around a lot of issues in the US and Europe and everywhere else. We continue to train at the bottom. If you can do this with your inventors, please do it, because it does two things for you. First of all, it tells your story. It tells the story of how your machine learning model is implemented to continue learning. Sure. But another thing it does is it gets you around conventional issues with patent offices saying that machine learning models are basically algorithms. Because conventional algorithms don't retrain themselves to do it even better. Generally. I mean, some do, but in general, this is something that's sort of useful for the purposes of artificial intelligence machine learning. So if you can tell the story, you set yourself up for success in a way that is significantly better than you would normally expect. Now, I can't promise you're going to do well, because candidly speaking, like I said, all the patent offices have gotten much better at this than they used to be. So you're still going to have a hard time. But this is kind of how we have encouraged our clients to set themselves up for success when filing. So another approach that I've seen much more rarely, but you should be aware of, is what I call improvements to AI/ML itself. There are some instances in which inventors will come to you with hyper-specific implementations and improvements to machine learning models. I've had a few of these myself. They are extremely complicated. You will know when you get them because they are full of math that looks really scary. Like they're going to be full of all sorts of algebra and all sorts of equations. Then you know you got yourself an improvement to AI/ML. In these circumstances, this is my one exception that I'll give you. Yeah, you can go ahead and file input-output, because at this point, we're talking about improvements to the black box itself. The artificial intelligence machine learning itself has been improved. It's rare you'll get these except for hyper-focused clients. But if you do, you should be aware they exist. So again, I just told you all these things about what I do to get yourself into a system and to handle AI/ML. But if you find yourself with an improvement, absolutely. And an example of this is on the right-hand side. This is actually from a real patent that was indeed granted by the USPTO and the EPO, the JPO, and the KPO. Well, it's just a good example of the complexity of these patents. So again, if you get it, you'll know. So this is something that I used to show all of my clients because I want to scare them a little bit, and I'm sure all of you are sophisticated enough to know better, but it's extremely, extremely hard to get AI/ML patents, even in the best of circumstances. I have had some that, in my opinion, were clear, great, strong inventions, but nonetheless experienced significant pushback. In fact, there's one series I've been working on right now for the last 5 years that has been clearly novel and transformative, but candidly speaking, has experienced significant pushback. Now, a lot of it has been because, understandably so, most patent offices in any country are loath to give you a patent on anything that says AI/ML without significant pushback. They're scared of it because they don't want to give you an easy patent, obviously. But part of that is also just because, again, you can analogize machine learning in the general sense to algorithms, and that can be a bit of a problem. So you have to be aware that even under the best circumstances, you're going to get a lot of pushback. So what I would advise you is if you're talking to clients about this, if they're considering filing anywhere, warn them, hey, this is going to take a long time. You've got something cool here, but don't expect this next year. Expect this 3 years from now. It sucks, but it's the truth. Now, this is something I show all of my associates who work underneath me about how to draft these things. So, a lot of this is up to personal preference, but I'll give you kind of the short script. If you're working on this, here's what you've got to keep in mind. When you're doing AI/ML, you have to draft patents a little bit differently because you are trying to convince the patent offices this is not some boring nonsense. This is not just you trying to get something on the patent office. You're not trying to trick anybody. So what I like to do is I like to start very simply, and like a European patent office examiner would what is the story here? What's the problem we're trying to solve? In the US, you wouldn't do that. Actually, if you're drafting in the United States, starting off with this is the problem is actually kind of a bad idea. However, in this context, I would say you have to do it. You have to say, look, without the improvements afforded by machine learning, this would not be easily doable. This is an improvement above and beyond something that can be done with a conventional computer. I'm improving the functioning of computers by doing X, Y, Z. It seems a little laborious, but I would highly recommend you do it because, again, you are fighting an uphill battle. You are in an area where the patent offices have seemingly decided that they are against you on this. So you got to kind of give yourself as much as you can. And again, one thing to keep in mind is obviousness rejections are a very real thing. So you can't just say, oh, this thing's cool because we added machine learning. You've got to explain why it's better than conventional solutions. You've got to explain why this is unexpected, a combination of unexpected, different concepts. So you got to do yourself a favor here. So that I highly recommend if you're talking with clients, especially sophisticated clients, because they tend to really want those super sparse, hyper-focused patent applications, you've got to be clear with them. You absolutely must tell your story. You have to be blunt, you have to be open, you have to be sort of verbose. Another thing is you have to be realistic. Inventors will come to you and say, I did this cool thing with artificial intelligence, full stop, please give me a patent. And you're just no, sorry dude, can't do that for you. You got to do more than that. So you need to go very early on when you're doing your invention disclosures, when you're talking to clients, when you're working with in-house counsel, you've got to be realistic with them. You've got to tell them, look, the idea that you can take this problem and try to throw machine learning at it is probably something that could be addressed through an obviousness rejection, so we've got to dig in a little bit. It's a good client expectations matter, honestly, because they tend to be more understanding when you explain to them, look, this is a tough area. So I would just advise you that if you're talking to them, you've got to be very honest. Another strategy that we have used very successfully and I would consider in your respective jurisdiction would use fast track procedures. So track 1 in the United States, for example, there are expediting processes in Europe. I recommend any of those. The reason being is because you want prosecution to operate fairly quickly. In my experience, the first 2 office actions in any country are typically not that great because the examiner is still cutting their teeth on what they're doing. At least in the United States, the number of hours they have to work on each application is quite low nowadays. The points system they're afforded is quite onerous. So you have to be realistic with yourself. You have to realize that they're not going to fully get your idea until second or third office action. And that sucks, and it's unfair, and it arguably should be fixed. But until then, I'd highly recommend you expect that to come down. So if you can speed up the process and you can get in front of that examiner with interviews and with a fast track procedure, and if you can be sort of annoying to them, you're better off. Another thing is, and this is something that I tell a lot of inventors, the first patent is probably not going to be the best. So I'm sure that many of you know how to do this, but I'll tell you the idea anyway. In the US and Europe, anywhere else, the usual idea is your first patent application, your first set of claims, even the first granted set of claims, especially in the United States, is not going to be the greatest. And that's okay, as long as you have an opportunity for a continuation, a divisional, etc. It is a very valid strategy in these things. We do this all the time. To let that first patent application get granted with claims that we would never litigate, and we would never license, and we would never sell, or we would never deal with. The reason being, obviously, we get our foot in the door. We convince the patent office, look, you allowed this once. So in the continuation, you should allow it again with broader claims. And by that point, you can begin to have a negotiation about what is and is not new. And this is not, I'm sure most of you know this, but this is something you especially have to keep in mind with these, because sometimes you might have to accept that your very first granted patent application, or granted patent, your first in the family, is going to be less than ideal, because you have to fight them on this until they understand what the real novelty is there. And this is especially the case with AI/ML. I've already alluded to this, so I won't go into it deeply, but again, please draft defensively. We have found significant difficulty when the specification was drafted too narrowly. So I'll give you an example without naming the client. I have one client that absolutely loves to be, what they call it, litigation-ready patenting. What they mean by that is the patent should only say things as briefly as possible with no explanation, and that way when we get to lawsuit, we can construe the terms any way we want to. So we can get them on the litigation. That doesn't work, especially in this area. You've got to tell a story, you've got to get into detail, you need to be honest about what you have and have not invented. That litigation-directed patent strategy that used to be popular in the United States in particular does not fly here anymore. You know, we're too global now, the patent office is too smart, just don't do it. Another thing that I like to do, and this is controversial even with my own firm, so you feel free to hate me on this, is I like to make my 103 case kind of explicit. So what I will do, literally within the patent specification, is say, look, artificial intelligence is known. Everyone kind of is aware that if you can staple an AI model to this, you probably should. Or you can, if you want to. However, this is different because X, Y, Z. Just go ahead and say it. There's no reason not to. I mean, your client might freak out momentarily, especially if they're sort of, again, litigation focused. But you have to be honest with yourself about what's going on here. So if you can, just be blunt. Go, look, we know that for the last 20-some years, everyone has been doing this land grab in artificial intelligence. Everyone wants these patents. We sure as hell do too. That's why we filed this. But let me tell you why it's different. That's what you got to go after. Some of your clients will hate you for doing that, so be careful. So let me talk about one issue that we've also seen on the back end of this. So once you get your client a patent, you've got another issue, which is figuring out how the hell to enforce it and how to actually get money for it. This is a very still real issue, and honestly, there's not many good answers. But I'm going to try to at least answer a few. One issue that virtually every single client that we have has is that they don't know where they can actually enforce their AI ML patents. The easiest situation is where the models are located in some discrete location like the server farms. Sure, right? You can kind of go after the server farm. You can go to the location of the server farm. Unfortunately, realistically speaking, it's a bit harder to track down this stuff if it's more distributed. Say it's on a widely distributed cloud. Say it's being performed in some country that does not respect any of the patents we have, or just is in an area where we don't have a patent in the first place. It's kind of a problem. And realistically, this is the same problem that we've had with software for a long time. You can kind of do this anywhere. As long as you have internet connection and decent computers, you can kind of do it anywhere. I mean, there's cases. I mean, I'm sure some of you have heard the Israeli company that was doing teeth scans where they would email themselves pictures of your teeth to Israel and then email that to, I believe, somewhere else like Pakistan or something, so that way they weren't infringing the patents correctly. This was all one big game to make sure it was all moving at the same time, but you got your teeth, so you're fine, right? But that's kind of how this rolls. You cannot expect that it's all going to be one location. It's not going to be down the road or something. So what drives this valid? I'm going to be very honest with you and say this is kind of a complicated idea, because realistically speaking, some of this is not going to work as much as you would think. Let me give you an example. Obviously, you can go talk to your client and figure out how much it costs them to develop their invention. They can probably figure that out. It might be made up, but they'll give you a number, right? Hypothetically. In terms of potential profits, you can probably put a number on it, right? You can probably figure out how valuable things are. Now, I'm going to be honest with you and say that's kind of much more hard than you would think, but just bear with me for a moment. The real issue is, and this is something we run into in the United States, and you might run into in your respective jurisdictions, is it's hard to snatch royalties in this thing. Because who the hell knows how much this AI is actually playing? So let me give you an example. Let's say I invented this cool new AI model for language translation. It's better than everybody else has done. It's the best AI model for language translation you've ever seen. So there are many other algorithms and systems that allow for language translation. So the question you have to ask yourself is, all right, how much is that worth in relation to, say, existing methods? Google Translate or whatever. It's kind of tough. And if you begin to extrapolate, you begin to realize it's kind of hard to put an actual number on this stuff. It gets kind of difficult. And again, you're not quite sure because in some cases this stuff is never actually quite used. So you have to be somewhat careful. Again, this is an example I just provided you, valuing Google Translate. Remember, Google Translate's free. I hate to break it to you, but a lot of AI and ML inventions actually are provided for substantially free. So again, you're going to have a problem here with royalties because they might not be willing to pay you a thing. Now, of course, we can get into this quibble about maybe Google will pay for it because it drives people to their site and everything else, but in general, it's quite difficult. So one thing I point my inventors to, and I'm sure you do this already, but I'll just mention it, is you should talk to your inventors about other ways to protect their ideas. In the United States, at least, copyright is a method to get around some of these problems. In other words, if your inventors have created a very unique code as part of developing their AI ML, needless to say, you should be talking to them about copyrighting it. Now, one problem with this, as many of you will probably appreciate, is the whole kit and caboodle here is because it can teach itself. And a lot of times these guys are changing this code on a daily basis, on an hourly basis. They're constantly innovating. So copywriting it, I mean, of course the copyright attaches immediately, but it's not like you should be going to register this thing. It's probably not going to make any sense. And the second idea is, and probably most valuable one, obviously, is trade secrets. Like, honestly, this is probably where the majority of our protection exists right now in the United States, because candidly, this patenting side of things is not working out very well. So, let me give you an example of something I've had my inventors do in real life. So, I had a bunch of inventors who they were working on an AI ML invention. They were doing very well for themselves. However, they were changing every day, and they had a very well-known, monolithic, well-known technology company who they believed were stealing their code. Now, we could go try to patent their artificial intelligence invention, but candidly speaking, that was going to be difficult. They didn't have the money for it, and we were on the line. It was going to be tough, right? And copywriting wouldn't make any sense because I just told you they were changing the code constantly, so that didn't work. So what would we do? Well, I had them put in dummy code and alter code from then on. The reason being, because we thought the big company is going to steal it. So we figured, all right, well, we need proof at least. We can keep this as a trade secret, put some dummy code in there, and the best thing you can do at this point is just hope that if you find that dummy code somewhere, you're fine. Now, most of you will appreciate that this is still going to be a big pain in the butt, because it's all server-side, so good luck proving it. But we can try. So again, this is all extremely difficult, and there's no good answer to it. What I try to think about is provide your clients toolkits, not necessarily an answer. It's hard to provide them an answer at this point. Just try to get as close as you can to a solution that works for them. This tends to work better for my startup clients just because they're happier about it. Telling them to throw in a function or two that's got a weird name is usually okay. And this is something I show them, again, this is mostly client focusing, but nonetheless the idea is that you want to make sure that your clients understand that trade secret really is where a lot of the protection exists here. I've just tried to scare you a little bit about why you might not necessarily want to go get a patent and direct it to AI and ML. What that means, in other words, is you should be directing them towards trade secrets as much as you can. If you can. But again, it's up to them. So what I would say is, what we have found success in, and I've already alluded to this, so I'll say it again, with your bigger, more sort of monetarily sound clients, there's nothing wrong with pushing them towards patents. As long as you tell them, look, this is going to take multiple years, you're going to have a patent examiner who is more or less against you, and you're going to be in a situation where you're not going to get exactly what you want, especially on the first round, realistically. And most of them will be sophisticated enough to understand this. For your startup clients, I would push them more towards dummy code. I push them more towards trade secrets. I push them more towards things that are more palatable to them right now. Because telling a relatively small startup, hey, give me $30,000 for a patent application, I'll get that to you in 3 years, they're not going to answer your phone calls anymore. So just don't bother. So that's the end of my section of this presentation. I'm happy to answer questions if you want to leave them at the end.
Is there any questions?
Sure.
First of all, very nice presentation. Thank you for that. Yeah. I came from, or I'm from a university perspective, and I like the last model, AI. We have professors, very prolific professors, come with inventions every day, keeps us busy. I like the trade secret with AI. One challenge I have, and this is the question really, is that to see your thoughts on, they like publication, those guys. So I'm not sure how to navigate that. Is a patent would be a good strategy? Does it help at all? Or how you see that part?
So it's funny because this exact issue I had down the road at Chulalongkorn University. That's where the slides come from, is this problem. So this is a very common university issue. The truth of it is, what I like to say is it's more about establishing that connection with them, because realistically we both know that they're going to want to publish no matter what. And a lot of their stuff is probably not worth protecting that strongly. I mean, it depends on how much you want to protect it, right? So what I have tried to encourage our university clients to do is to establish a touch point with them regularly and to check to see what they're working on. And then there's certain areas you might just have to be okay with saying, all right, go ahead and publish it. Go talk about it at the conference because you're going to do it anyway. Just go ahead. But the reason I say this is because sometimes you can catch them right before they do something very cool, and you can eventually, at least get a provisional application on file. So with a university in the United States, we do exactly that. We say, look, about every month before they go off and go to a conference without you checking on things, you look at it and go, okay, we're going to have an open conversation about what you're working on. And then there's some of the stuff that, have fun, go talk to your friends about it, who cares. But if you see something really valuable there, you immediately hit the brakes on them and you tell them, look, I need at least a week to get a provisional on file. We're going to file your papers as they are. Then you can go brag about it to everyone you know. And it also depends on how things work. Like some universities that I work with, both in the United States and abroad and here in Thailand, they have the ability to file provisionals for nearly free. So it makes it a bit of an easier process. You just throw it at the government and forget about it for a while. However, if it costs you a lot of money, maybe that balancing act gets a little bit different. But for the ones who have free provisionals, I just file it until they tell you not to.
Yeah. Thank you very much.
Any more questions for Kirk? We may also ask after the end of the last panel. So thank you very much for Kirk's very comprehensive presentation. Now we will